All right. Floor is yours.
This working? Okay, very good.
Working now.
Okay. Mr. Chairman, these two particular witnesses have a lot of filings and exhibits, so I'm going to go through and move to enter those before we get to summaries, just for the convenience of the court reporter, if that's okay. Mr. Gartitego. Oh, have we been sworn? You've been sworn? Okay, sorry.
I do.
Mr. Gartitego, please state your full name and business address.
Kojo Gartitego. Business address is 40 West Broad Street, Greenville, South Carolina, 29601.
And by whom are you employed and what capacity?
I'm employed as president of Duke Energy South Carolina, which also means I'm president of Duke Energy Progress and Duke Energy Carolinas.
And Mr. Gartitego, did you cause to be pre-filed in this docket direct testimony consisting of 38 pages?
I did.
Okay. Do you have any changes or corrections to your direct testimony?
Yes, I would note that on page 7, line 15, I make reference to a Joseph A. Miller Jr. filing testimony in this case. He's been replaced by Julie Turner. And so later on in line 18 as well as line 20, Witness Miller should also read Witness Turner.
With those corrections, if I asked you the same questions today, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time, I move that the pre-filed direct testimony of Mr. Gartitego be copied into the record as if given orally from the stand.
Mr. Gartitego's pre-filed direct testimony as corrected will be entered into the record as though given orally from the stand.
And Mr. Gartitego, did you cause to be pre-filed in this docket on March 18th, 2019, rebuttal testimony consisting of 18 pages?
I did.
And then on April 1st, 2019, did you also cause to be pre-filed in this docket revised rebuttal testimony consisting of 16 pages?
I did.
Does your revised rebuttal testimony replace your rebuttal testimony?
It does.
Okay. And if I asked you the same questions today, would your answers be the same?
Yes, they would.
Okay. Mr. Chairman, at this time, I move that the pre-filed revised rebuttal testimony filed April 1st by Mr. Gartitego be copied into the record as if given orally from the stand.
Mr. Gartitego's revised rebuttal testimony pre-filed on April the 1st will be entered into the record as though given orally from the stand.
Okay, thank you. Ms. Bateman, please state your full name and business address.
My name is Laura A. Bateman, and my business address is 411 Fayetteville Street, Raleigh, North Carolina.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas as a Director of Rates and Regulatory Planning.
And on November 8th, 2018, did you cause to be pre-filed in this docket direct testimony consisting of 42 pages and Bateman Exhibits 1 through 4 consisting of a total of 36 pages?
Yes.
Do you have any changes or corrections to that direct testimony?
No, I do not.
If I asked you the same questions today, would your answers be the same?
Yes.
Okay. Mr. Chairman, at this time, I move that the pre-filed direct testimony and Bateman's Exhibits 1 through 4 be copied into the record as if given orally from the stand.
Ms. Bateman's pre-filed direct testimony will be entered into the record as though given orally from the stand. Her Exhibits 1 through 4 will be entered as hearing exhibit number 14.
Ms. Bateman, did you also cause to be pre-filed in this docket on January 18th, 2019, supplemental direct testimony consisting of 8 pages?
Yes, I did.
And then did you cause to be pre-filed in this docket on January 22nd, your supplemental direct testimony consisting of 8 pages to also include Bateman Supplemental Exhibit 1 consisting of 1 page and updated Bateman Exhibit 3 consisting of 8 pages?
Yes, I did.
Do you have any changes or corrections to that supplemental direct testimony or exhibits?
No, I do not.
If I asked you the same questions today, would your answers be the same?
Yes.
Mr. Chairman, at this time, I move that the pre-filed supplemental direct testimony and Bateman Supplemental Exhibit 1 and updated Bateman Exhibit 3 be copied into the record as if given orally from the stand.
Okay, Ms. Bateman's supplemental direct testimony will be entered into the record as though given orally from the stand, and her supplemental Exhibit 1, supplemental Exhibit 1 and updated Exhibit 3, supplemental Exhibit 1 and updated Exhibit 3 will be entered as Exhibit number 15.
Ms. Bateman, did you also cause to be pre-filed on this docket second supplemental direct testimony consisting of 4 pages, Bateman's second supplemental Exhibit 3 consisting of 4 pages, and Bateman revised second supplemental Exhibit 3 consisting of 4 pages?
Yes, I did.
Do you have any changes or corrections to your second supplemental direct testimony or exhibits?
No, I do not.
If I asked you the same questions today, would your answers be the same?
Yes.
Mr. Chairman, I also move that the pre-filed second supplemental direct testimony of Ms. Bateman and Bateman revised second supplemental Exhibit 3 be copied into the record as if given orally from the stand.
Ms. Bateman's pre-filed second supplemental direct testimony will be entered into the record as though given orally from the stand, and her second supplemental Exhibit 3 revised will be entered as Exhibit number 16.
And Ms. Bateman, on March 18th, did you cause to be pre-filed in this docket rebuttal testimony consisting of 33 pages and Bateman rebuttal Exhibits 1 and 3 consisting of a total of 3 pages?
Yes, I did.
And then on April 1st, did you cause to be pre-filed in this docket revised rebuttal testimony consisting of 26 pages?
Yes.
Does your revised rebuttal testimony filed April 1st replace your rebuttal testimony?
Yes.
And do your Bateman rebuttal Exhibits 1 and 3 remain the same?
Yes.
Okay. Mr. Chairman, at this time, I move that the pre-filed revised rebuttal testimony of Ms. Bateman and Bateman rebuttal Exhibits 1 and 3 be copied into the record as if given orally from the stand.
Ms. Bateman's revised rebuttal testimony will be entered into the record as though given orally from the stand, and her revised rebuttal Exhibits 1 through 3 will be entered as hearing Exhibit number 17.
Thank you. This time we'll move to summaries. Mr. Gartitego, do you have a...
Hang on one second. I think Commissioner Belzer has a quick question.
I apologize, Ms. Smith, but this is crazy, let me say. Okay, but with regard to Ms. Bateman's revised rebuttal testimony that was filed on April 1st, were there exhibits attached to that revised testimony?
No, ma'am, they were not. So she revised her rebuttal testimony, but her original rebuttal Exhibits 1 and 3 remain the same.
Okay, thank you very much. Everything that you've put in, do any of the latter filed exhibits just totally replace the earlier filed ones? Do we need all reiterations of the exhibits in the record?
I think they go to different positions that the company has had during the time frame of the case, and to be honest, I tried to find a way to avoid it and couldn't.
Well, I'm kind of getting lost in hers, and I'm trying to simplify things. But
yes.
Thank you very much.
Thank you. Continue.
Mr. Gartitego, do you have a summary of your testimony in this case?
I do. Good morning, Mr. Chairman and Commissioners. We're here today seeking a change in rates to reflect our continued investment in the state of South Carolina and the cost to provide safe, reliable, cost-effective, and increasingly clean electricity to our customers. As I described in my direct testimony, Duke Energy Progress has continued to invest in our facilities, equipment, and operation to better serve our customers. For example, the company placed into service 2 new combustion turbines at Sutton Combined Cycle Plant, providing an additional 78 megawatts of capacity to the company's fleet. These units and their increased capacity are critical to the ability to restart the generation system in the event of a catastrophic storm and provide off-site power to Brunswick Nuclear Station. The company's total investment of the Sutton Combined Cycle Plant totaled $101 million. Investments like this provide benefits to our customers for decades to come. The company has also started the process to comply with state and federal regulations requiring the company to address coal ash basin closures at plants which have served or are continuing to serve customers in South Carolina. Duke Energy recycled more than 78% of coal combustion byproducts in 2017, and that includes Duke Energy Progress recycling or beneficially reusing the ash that is produced at our coal-fired plants. We have worked hard to reduce our impact on the environment by retiring older, less efficient coal plants across the Carolinas and have retired all our coal plants in South Carolina. And now we are closing all ash basins as part of new sweeping state and federal regulations as part of Duke Energy's commitment to provide increasingly reliable, cleaner power to customers at reasonable rates. Like any waste, we must ensure that coal ash is managed responsibly. Additionally, we are planning for the future by developing and installing a new customer information system to ensure the best customer service possible by beginning a full rollout of AMI smart meter technology within the Duke Energy Progress territory. And based on customer feedback, we request to offer fee-free payment programs for residential customers for all methods of payment. We believe it is necessary to make these investments to better serve our customers. We know that these smart investments in technology, infrastructure, and environmental protection will help connect millions of our customers to the energy future they expect. In my rebuttal testimony, I addressed major concerns that were raised at the time by the Office of Regulatory Staff and other interveners. The first issue that I address is ORS's suggestion that South Carolina customers should not have to pay for costs which the company incurred to comply with North Carolina's Coal Ash Management Act, also known as CAMA. Historically, the company's generation, fuel, and associated costs are allocated between South Carolina and North Carolina, and we believe it is appropriate for the CAMA compliance cost to be allocated between the two states, much like our costs for addressing ash basins in South Carolina. The second issue concerns some fundamental disagreements on the company's proposed return on equity and deferred costs. The ORS has taken a contradictory position to effectively disallow costs the company has incurred to finance deferred costs. ORS claims it will allow the company the full cost of recovery over an extended period of time, but also suggests lowering the allowed return on equity based on such deferrals. The ORS's and other parties' suggested lower return on equity will put the company at a disadvantage in the capital markets and would be a disservice to customers. I am also concerned with the ORS's recommendation to disallow expenses related to employee compensation and employee recognition and engagement. The company has an obligation to be responsive to the market for talent and assure the competitiveness of the total compensation package it offers its employees. We need to keep employees engaged and well-trained. Businesses with more engaged employees have lower levels of turnover and higher levels of productivity and customer satisfaction. Experienced, engaged employees that are incentivized to remain with the company, to work in a safe manner, and to provide high service levels benefit our customers. The ORS also recommends the disallowance of costs to participate in local organizations in the communities that we serve. Organizations like chambers of commerce, economic development associations, and tourism organizations all exist to support existing businesses and to bring more industry and residents to their regions. Duke Energy pays dues to be a part of those organizations because we believe it is important to participate in the communities we serve and to be engaged at a local level to ensure we understand our customers' needs. For example, our participation in such organizations gets us to the table early for economic development opportunities, which benefits our customers and the state. Our contributions to these organizations have a direct link to winning projects for the state of South Carolina. I also addressed the reactions to the company's proposal of a cost-based basic facilities charge, which is charged to each customer. We believe that an increase in the basic facilities charge will ensure that low-usage customers are not subsidized by other customers, and that the increase will reduce volumetric billing spikes that typically occur in summer and winter months. I note we do not contest the basic facilities charge figures proposed in ORS witness Seaman Wynn's rebuttal testimony of an $11.78 basic facilities charge for residential customers, $12.34 for small general service customers, and $11.31 for small general service constant load customers, and to put the remaining revenue requirement ultimately determined by the Commission in the variable component of such rates. With this change to the basic facilities charge, residential customers will pay less than 40 cents per day to have electricity available for when they need it. The company realizes that regardless of how justified a rate case may be, there is no good time to raise customer rates. In ongoing conversations with customers and listening to testimony at public hearings, and after reading relevant testimony and comments filed by interveners and customers, we continue to hear the concerns of our customers. The company wants to help customers understand their energy use, empower them to save money on their electric bill, and provide programs for every type of energy user and budget, and continue to power the lives of our customers in South Carolina. This concludes the summary of my direct and rebuttal testimony.
Thank you, Mr. Gartitego. Did you also attend the public hearings the Commission held in this case in Florence and Sumter, April 1st and 2nd, respectively?
I did.
Okay. What is your reaction to customers at the public hearings who questioned whether the company's rate request is justified?
I want to make clear that we have been transparent in this case. It is important that our customers, this Commission, the ORS, and all interveners understand our request. We have provided direct, supplemental, and rebuttal testimony of 19 witnesses, including myself. We have provided filings with approximately 2,600 pages of exhibits and testimony. We have sent bill inserts, made information available on our website, dispatched automated phone calls to our customers, and placed newspaper advertisements about this case and the public hearings. We have engaged in active discovery, providing responses to over 1,600 data requests, including subparts, which contain thousands of files in this case, almost 4,000 invoices, and we produced supporting documentation requested in discovery of thousands of pages and spreadsheets. And of course, we're here today to answer the questions of case participants and the Commission. I realize that all of that activity may not be top of mind for those who attended the public hearings, but I think it is important for that to be heard in this venue where I have an opportunity to speak.
Mr. Gartitego, what is your reaction to customers at the public hearings who expressed concern about the company's presence, activities, and customer relations in the PD area?
I want to stress that the company and its employees make great efforts to be partners in the communities in which we live and work. That is part of our corporate purpose, which is to power the lives of our customers and the vitality of our communities. In addition to the investments that Duke Energy Foundation makes in the state, including the PD, our employees are encouraged and willingly share their time and talents with the communities by volunteering for local nonprofits and by making charitable contributions to many organizations in South Carolina. In fact, in the test year for this case, South Carolina employees volunteered 13,853 hours and donated $337,740 to nonprofits to support education, human services, arts and humanities, community vitality, and health. I continue to be impressed by the selfless giving of our employees, and our company has dedicated funds to assist employees' efforts to support local organizations. This assistance comes in the form of two signature programs. We have a program called Dollars for Good, which will match an employee's $100 minimum donation to eligible organizations, and Hours for Good, where employees can volunteer a minimum of 10 hours with an eligible organization and earn that organization $100 up to $2,000 per calendar year. These programs and volunteer opportunities are extended to Duke Energy's retirees, who continue to represent the company in the community long after they hang up their hard hats. We also have district managers who work in this area, and while we no longer have local offices, we do have employees and work and live. We do have employees who work and live in this area, and I am a frequent visitor myself to the PD. I commit to strengthening our connection with this community, including investigating more direct points of contact for customer groups like our farming customers.
Mr. Garchitego, what is your reaction to customers at the public hearings who questioned whether they could afford the increase that the company has requested?
I do hear the concerns of our customers who have difficulty paying their bills. The company's community impact continues through our Energy Neighbor Fund and various energy efficiency programs that we offer to our customers. The Energy Neighbor Fund is a financial assistance program that has provided $3.2 million to DEP South Carolina customers since its inception. And the energy efficiency programs can and do help customers manage their usage to lower their bills from what they would otherwise be. All customers are eligible to participate in programs like the Lower My Bill Toolkit, Smart Saver, and Home Energy House Call. We also have programs targeted to our lower-income customers like Share the Warmth, Shared Solar Low-Income Assistance, and Neighborhood Energy Saver. And we provide links to state-level resources on our company's website. Many of the programs mentioned aim to teach our customers about energy efficiency and how to better control their usage and bills. Duke Energy has been a trusted provider of electricity in South Carolina since 1904, and we want to continue making meaningful contributions to the well-being of the state. That is why I continue to advance ideas like the Roundup program that was suggested by Commissioner Irvin and advanced by Commissioner Howard through the upcoming ex partes.
Mr. Garchitego, have you further investigated the concerns raised by the agricultural community present at the public hearings?
Yes, I have. And as to the farming community so vital to South Carolina, first, let me say prior to the public hearings, the Florence County and the Marion County Farm Bureaus reached out to our company expressing concerns about the proposed rate increase in the basic facilities charge in particular. After the hearing, we also received an identical letter from the Darlington County Farm Bureau. I responded in writing to each letter and, among other things, informed them we had heard them and would accept the lower basic facilities charge of $12.34 per month for the SGS customers as proposed by ORS. Schedule SGS is used for billing the majority of farm accounts. At the hearing, I learned that several farms also had accounts on Schedule MGS. After the public hearing in Florence, I promptly pulled a team together to look into how we could help our agricultural customers further. We looked at rate structures to ensure customers we were able to identify as agricultural accounts are on the most beneficial rate structure. Upon review, we found that a majority of the farmers under Schedule MGS could actually lower their bill under an alternate schedule without even changing their consumption. We therefore began reaching out to each of these farmers to explain the opportunity to save by changing rate schedules. The remaining accounts have higher monthly bills and shouldn't be adversely impacted by the basic facilities charge. Witness Wheeler can provide additional detail regarding our efforts.
Mr. Garchitego, have you further investigated the concerns raised by a customer at the Florence public hearing who had a substantial unauthorized withdrawal from his banking account?
Yes, I have. There was a customer who experienced an unintentional withdrawal of $9,619.13 from their bank account. And I was very concerned about it, and I have learned much more about the instance. First, let me say this was a confluence of the perfect storm, in more ways than one, actually. You may recall that last year, our territory was significantly impacted by Hurricanes Florence and Michael. The aftermath of these storms also created operational billing issues for Duke Energy Progress. They were significant enough that we reached out to the ORS and also filed a letter dated December 5th, 2018 with the Commission, describing the issues and the backlog of issues requiring manual action. Unfortunately, Mr. Irvin's account was one of the few that were adversely impacted in this way. Simply, after a couple of months when we were unable to read the meter at Mr. Irvin's property, our existing Customer Information Management System, or the CIM billing system, inadvertently and erroneously calculated an extraordinarily high usage for Mr. Irvin's property. And before we could manually intervene, the billing system implemented the automatic electronic fund draft from his bank account that had previously been scheduled. The failure of timely intervene was due to the extraordinary backlog that had accumulated largely because of the storms. Once the error was identified, we reached out to Mr. Irvin and sent him a refund by overnight mail. This was a rare circumstance, and I do not expect that it would happen again, particularly after our new proposed Customer Connect system is fully implemented. In the meantime, to prevent this from actually happening again, the DEP billing team now uses an IT query to identify bank draft customers with open work items. In addition, the team is working with our technology group to implement a change in the work routing system where work items for customers on the bank draft program are assigned to performance as the highest priority.
Mr. Gartitego, did you further investigate the claims regarding the tobacco barn, which burned down, and there were allegations that the company was at fault? Do you recall that?
Actually, as I recall, it wasn't, the barn did not burn down. I think it was an issue of tobacco in the barn.
Thank you.
Not properly curing, and so loss of goods there. And these were raised by customer Dupree Atkinson, I believe. I reached out to our claims and distribution teams and learned that upon Duke Energy's initial response to an outage that was reported on August 13, 2016, our service technician noticed that the lines were installed incorrectly and that connection had failed. Unfortunately, the connection was not retained as evidence at that time because of a lack of evidence and subsequent storm damage from Hurricane Matthew. The subcontractor hired by Duke Energy to install the original connection was not willing to accept total liability. And this is important because I think one of his concerns was that it took us a while to get him his money to satisfy his claim. But in any event, after investigation, Duke Energy deemed it necessary and our responsibility to pay a settlement to Mr. Atkinson for his loss. Our team has appropriately addressed the issues of this case and has taken measures to ensure that this does not happen to other customers. We are training Duke Energy employees and subcontractors so that installation mistakes are avoided, and we are also educating our customers on proper mitigation steps they can take by installing a warning system for future outages.
Did you also look into the concerns raised at the public hearings about the company's vegetation management practices?
Yes. And as to the concerns raised about our vegetation management practices in regards to our treatment and removal of danger trees that can impact the company's transmission right-of-ways, our vegetation management team continues to provide ample notice to customers prior to trimming and removing of trees by use of door hangers, telephone calls, and mailers. We will work with those customers if they respond on things like timber issues, which is one of the concerns that was raised. We will continue to stress the importance of the vegetation management team's role in communicating and educating customers that are affected by right-of-way management in order to reduce further customer satisfaction or dissatisfaction.
Does this conversation that we're having today fully convey the attention you placed on the issues that you heard at public hearings?
No, and I want the Commission to know that I continue to have my team look into each and every concern raised at the public hearings. We take each issue seriously and always look for ways to improve. Some of those opportunities for improvement are already underway, including our implementation of a new Customer Connect system to improve the customer experience for all. Other opportunities need new work streams, especially when it comes to customer communication. But I have to note that we have hundreds of thousands of customers in this state, and about 170,000 of them in the Duke Energy Progress territory. And I am proud of our service to our customers and think it's important to put the quality of our service into perspective. For example, over the past 3 years of the J.D. Power Residential Customer Satisfaction Study, if Duke Energy Progress in South Carolina was measured as a standalone utility, we would rank at or near the top of large utilities in the southern United States.
Mr. Chairman, Mr. Gartitego, I hate to interrupt. ORS certainly has no objection to Mr. Gartitego responding to issues raised at the public night hearing. I believe Ms. Smith asked Mr. Gartitego about vegetation management. It just seems like Mr. Gartitego's response may be going a bit far afield here.
I think the last question was, did you investigate claims regarding, what are my thoughts regarding other issues that were raised at the public hearings?
I may have misheard. I apologize.
I'm sorry.
Continue.
And the discussion of the J.D. Powell study is also in my direct testimony. But I just want to emphasize that the J.D. Powell study does not single out Duke Energy Progress South Carolina. It does it on a utility-wide basis. So their reports reflect the results for Duke Energy Progress in total, north and south. But we get enough data that we can peel out the South Carolina responses. And what I'm saying is, if you just evaluate the South Carolina responses, we would be at or near the top of large utilities in the southern United States. J.D. Power conducts national online surveys with utility customers, asking them to rate their utility across multiple measures. Approximately 100,000 surveys are completed nationwide on an annual basis. Each utility's customer satisfaction index is calculated based on the rating scores customers give their utility on the aforementioned measures. Therefore, a utility's ranking is a direct result of the scores given by their customers. Duke Energy Progress customer scores in South Carolina have consistently surpassed national top quartile performance thresholds on the overall customer satisfaction index metric, as well as within all 6 measure component areas, including power quality and reliability, price, billing and payment, communications, corporate citizenship, and customer service. In regard to large business customer satisfaction, according to the J.D. Power Electric Utility Business Studies, Duke Energy South Carolina would have finished in the top quartile among large utilities nationally in 2016, 2017, and 2018 if we had been measured as a standalone utility. Therefore, in evaluating the concerns being raised, it is not only important for us to investigate them, but also to put them into perspective with how we're doing overall. Thank you.
Ms. Bateman, do you have a summary of the testimony you filed in this case?
I do.
Could you provide it now?
Yes. Good morning.
Did we pass out copies of the summary?
Good morning, Mr. Chairman, members of the Commission. I filed direct, supplemental direct, rebuttal, revised rebuttal, and second supplemental direct testimonies in this case. My direct testimony discusses the results of Duke Energy Progress's operations under present rates on the basis of an adjusted historical test year using the 12-month period ending December 31, 2017, and supports the pro forma adjustments to the test period. My direct testimony also explains the accounting requests the company is making and the company's request for the approval of an excess deferred income tax or EDIT rider. My supplemental direct testimony, I present certain accounting and pro forma adjustments and present additional adjustments to the company's cost of service. I also present updates to the company's proposed EDIT rider. In my rebuttal testimony, I address several accounting and rate-making adjustments proposed by the Office of Regulatory Staff with which the company disagrees. In particular, I oppose the ORS recommendation that the company be disallowed a return on the incremental costs which the company has deferred in a regulatory asset on its books during the deferral period. I also oppose the disallowance proposed by the ORS, which would deny the company its carrying costs during the amortization period for the portion of the regulatory assets that the ORS has identified as related to operating expenses. If the Commission accepts these proposals, DEP will not be able to fully recover its prudently incurred costs. The company incurred these costs in the past, and both the ORS and the company have proposed recovery of the costs in the future. There is a real cost of debt and a real cost of equity that the company incurs in financing the costs during this period between when the costs are incurred and when they are recovered. To disallow recovery of these costs would be to disallow prudently incurred costs, and no one suggests that these weren't prudently incurred or that they were not, in fact, incurred. My rebuttal testimony also addresses the ORS recommendation to disallow certain coal ash-related costs, which the company vigorously opposes, as explained by company witnesses Karen and Wright in their rebuttal testimonies. I also explain in my rebuttal testimony that although the company does not oppose the ORS recommendation to use an 8-year average expense level for storm restoration costs, we do oppose the ORS removing the inflation impact to storm costs. The company's adjustment is more reasonable as it adjusts each storm cost year included in the average to be comparable to the test year on an inflation-adjusted basis, which is appropriate as costs associated with storm restoration have significantly increased in the last 10 years. The company objects to ORS witness Kelvin Major's exclusion of annualized test period O&M non-labor expenses. The requested adjustment is very similar to the customer growth adjustment, which the ORS has accepted. Both adjustments annualize impacts from the test year average to the end of the test year, one for customer growth and one for inflation, and both are appropriate to include. Company witness Metzler also discusses this, but I provide an overview that Duke Energy Progress does not agree with ORS witness Major's recommendation to remove 50% of DEP's long and short-term incentive program costs. ORS witness Major further recommends to disallow certain rate case expenses due to alleged insufficient documentation to support the costs, specifically legal services provided by outside counsel and billed via an e-billing system. Duke has utilized an e-billing system for several years, as do many large companies, for administrative efficiency, and hopes that use of such a system is not a hindrance to cost recovery. The company also requested costs related to its Customer Connect project. ORS witness Payne recommended removing DEP's proposed increase to O&M as not known and measurable. An alternative to the company's request would be for the Commission to approve a continuation of the deferral of the incremental operating expenses incurred related to Customer Connect, the Customer Connect project, including a carrying charge on the deferred costs until the company's next general rate case. The company thinks this would be a reasonable alternative to its proposed recovery. In addition to these recommendations, I also oppose ORS witness Major's recommendation to remove certain expenses from O&M. Duke Energy Progress disagrees with the removal of the lineman's rodeo costs, employee incentives, service and safety awards, and any cost to recognize and reward the company's employees who serve our customers. The company further disagrees with the removal of organization dues in support of business, economic development, and the communities we serve. I also oppose witness Major's recommendation to disallow invoice costs when the payment and the service provided occur in different years, and to remove costs shared between North Carolina and South Carolina through allocation as opposed to being direct assigned by state. Finally, my revised rebuttal testimony withdraws certain portions of my rebuttal testimony based on the stipulation between Nucor and the company, and my second supplemental direct testimony explains the changes to the proposed EDIT rider based on the stipulation. This concludes the summary of my pre-file testimony.
Thank you, Ms. Bateman. I have a couple of additional questions for you, 6 to be exact. In the surrebuttal testimony of ORS witness Payne, did he cite a number of rulings from other state regulatory commissions regarding deferrals in support of his position?
Yes.
Those were not referenced in his direct testimony, correct? Do you have a reaction to those authorities?
Yes. First of all, I would say the states that witness Payne cites and the authorities that he cites none of them support the position that the ORS has taken in this case with respect to deferrals. So the states that he cites, he lists criteria that should be used to approve deferrals in certain states. And that's something that's more appropriate to discuss in a generic docket. I will point out that all of the deferrals that we are talking about in this case have already been approved by the Commission. And looking at other states to determine what criteria is appropriate for South Carolina going forward is important, but it should also be done in the context of a generic docket, and it should also be done in such a way that we can look at, for those states, do they have future test years? Do they have multi-year rate plans? Do they have multiple riders? Because those items will impact what criteria is appropriate for granting deferrals. And so I think this commission needs to look at what criteria is appropriate for South Carolina given our regulatory framework. And that's most appropriately done in the generic docket.
Did witness Payne also make reference for the first time in his surrebuttal testimony to accounting authorities not included in his direct testimony? For example, accounting for public utilities, the Deloitte manual, and a certain newly cited quote from the NARUC rate case and audit manual.
Yes.
Do you have a response to the use of those citations and their applicability to the issue of deferrals?
Yes. So first of all, on page 7 of Mr. Payne's surrebuttal testimony, he cites 2 new authorities, the Deloitte Regulated Utilities Manual and the FERC Electric Chart of Accounts. And then he introduces some new criteria that I think he thinks should be applied to deferrals, that they should be unforeseen or outside of management control. I want to be clear that that criteria is nowhere in the references that he cited. In fact, the Deloitte manual that he cites specifically lists rate case expenses as an example of a typical deferred cost. And so rate case costs would not qualify for those criteria that Mr. Payne is proposing, that deferrals be unforeseen or outside of management control.
In his surrebuttal testimony, did witness Payne provide for the first time his calculation of the aggregate impact of the deferrals at issue from his point of view?
Yes, he provided it from his point of view.
Does the company agree that this is the full financial impact of the ORS recommendations on deferrals?
No, I would disagree with that. Mr. Payne only calculates the annual impact, but the company will be experiencing that disallowance over multiple years. So the total impact would be much larger, and we calculated at approximately 3 times as much. And in addition, the fact that an impact is relatively small is not in and of itself a legitimate reason for a disallowance, no more than it would be a legitimate reason for a proposed increase. Like if I were to introduce a pro forma to increase expenses by $900,000, and my sole justification was that the impact was small, that would not be reasonable. And finally, I do think while he calculates the impact of the deferrals that we're talking about in this case, I do think it's important that the Commission keep in mind that the company has over $150 million of deferred storm costs. And those deferred storm costs have been removed from this case to mitigate the impact on customers. However, if the proposed logic that the ORS has applied to deferrals in this case were applied to those deferred storm costs, meaning no return on the deferred costs related to operating expenses, whether during the deferral period or the amortization period, that would be a huge impact to the company. So we think this is an important issue and is significant.
Did Mr. Payne also make statements on page 8 for the first time in surrebuttal alleging that only shareholders benefit from deferrals at the direct expense of customers?
Yes, he did.
Do you agree with that statement?
No. To say that customers have not benefited from the deferrals in this case is simply not true. Customers have benefited through the money spent for the underlying costs, plus customers have benefited from delays of and mitigation of rate increases that directly resulted from the deferrals in this case. And I think it would be helpful to provide a little background on the deferrals that we're talking about in this case. So if you look at the Fukushima and cybersecurity deferral and the Harris-Cola deferred costs, these were both part of a 2013 deferral petition that specifically stated that the deferrals would enable the company to delay a rate case filing. At the time, the ORS found value to customers in that benefit, and the Commission approved the petition. In the company's last rate case, the company was able to mitigate the increase to customers in that case by delaying recovery of and continuing the deferrals for 4 of the deferred costs in this case: the Fukushima cybersecurity deferral, the Harris-Cola balance, the 2014 storms, and the coal ash deferral were all part of the settlement in that rate case to defer recovery of those costs. And the ORS was a party to that settlement. Finally, in the last rate case settlement, we agreed to a 2-year stay out and had the expectation that we would be filing again for new rates effective 1/1/2019 when the stay out expired to start collecting the costs that we had deferred. However, last spring, the company determined that it could delay its rate case filing if it were able to secure certain deferrals and filed petitions for deferral for costs related to Customer Connect, AMI deployment, increases in depreciation rates, and the Grid Improvement Plan. The Commission approved those petitions. And even just a 5-month delay in increasing the increase benefits customers by anywhere from $10 million to $20 million, depending on the increase ultimately approved by the Commission in this case. So to say that customers have not benefited from the deferrals is simply just not based on the facts and not true.
2 more questions for you. As to ORS Witness Major's surrebuttal testimony. Witness Major recounts a conversation between the company and ORS about rate case expenses for the first time in surrebuttal. Is that correct?
Yes.
Do you have a response to the recounting of that conversation?
Yes. So my understanding of that conversation is very different. My understanding is that the ORS asserted that only paper invoices would be sufficient documentation for the legal invoices related to rate case expenses. And I have an email from our attorney to the ORS attorney that was sent after the phone conversation on March 1st, explaining the company's e-billing system, offering a variety of options on how to provide the information, including screenshots and an affidavit from the outside counsels.
Mr. Chairman, this is the hearsay, what Ms. Bateman is reading off of currently, and I would object to its introduction into the record, its testimony.
Would you like for us to introduce the email?
Ms. Shirley Smith, I would not. I don't believe that Ms. Bateman could authenticate the email to be introduced.
I have a copy. Would you like to review it?
I've seen the email, but I don't believe that either of these witnesses could properly authenticate it to be introduced into the record.
Okay, I'm going to overrule the objection. I want to hear it, but very succinctly.
Mr. Chairman, if I may, the email could be taken out of context. I understand the overrule, but may ORS be given the opportunity to present proper context? I don't have it on me, but at some point in time during this hearing.
Okay.
Thank you. The email from our attorney explains the company's e-billing system and offered a variety of options on how to provide information, including screenshots and affidavits from outside counsel. The ORS attorney responded that they would discuss internally and get back to us. They did not. Our attorney sent a follow-up email confirming that we were waiting to hear back from them on an acceptable format, and the ORS attorney never responded. After reading the allegations in Mr. Major's surrebuttal testimony that more detail was needed, the company has since provided this detailed information requested by Mr. Majors. However, we have provided it in electronic format. While I hope this resolves the issue, there is still part of me that is unclear as to whether or not the ORS will be satisfied with electronic invoices.
Last one. Mr. Major also briefly addressed his view of non-allowables in his direct testimony, but in surrebuttal, did he make a number of specific allegations about the ORS's view of non-allowables?
Yes.
And could you respond to those?
Yes. So in surrebuttal, witness Major claimed that the ORS was recommending disallowance of costs because the company did not provide sufficient documentation to support the transactions. I will note that the company provided over 64,000 pages of documentation for these transactions in question, and our accounting group spent over 1,000 hours pulling the documentation and organizing it in a way to make it easier to follow for the ORS. When we received the response from the ORS after providing this huge volume of information, they stated their recommended disallowance, and they were wholesale disallowance of all incentives, all service and safety awards, all chambers memberships at 50%. For the transactions that did have individual explanations, the comment said, recognition and reward not allowed, coffee not allowed, decorations not allowed, team lunch not allowed. There was even one transaction that was sunscreen for distribution field crews, sunscreen not allowed. This is not a case of lack of documentation, but a case of different perspectives of what should be recoverable. The company believes that these costs are just and reasonable in the provision of electric service and should be recoverable. And I did try to break down, because I know there's so many different transactions in this category, I did try to break down the costs a little bit further, just to provide some information to the commission. So, for example, the spot bonuses or exceptional contribution awards, those are approximately $117,000. The South Carolina Chambers of Commerce and other South Carolina economic development and community organizations, that's approximately $46,000. The Lineman Rodeo is $26,000. The Service and Safety Awards are $32,000. The allocations issue that I address in my rebuttal testimony is $4,000. The timing differences that I address in my rebuttal testimony is $12,000. There's a general category of recognition and reward not allowed, and this would include the coffee and the decorations and the team lunches as well. That's about $40,000. And then $97,000 was removed by the company. And the biggest category is the coal ash litigation costs, which were kind of added on at the very end. They weren't part of the discussions that Witness Major discusses in his SIR rebuttal, and that's $390,000.
Thank you. With that, Ms. Bateman and Mr. Garchie-Tago are available for questions.
Thank you. Okay. Walmart. Ms. Grunman.
Good afternoon. May I ask that the Elmo be on? Good afternoon, Mr. Garchie-Tago. I do, in fact, have some questions about your summary provided. I'd like to direct your attention specifically to page 3 of your summary. It's that first full sentence at the top of page 3. And I believe here you're talking about the returns on equity that have been proposed by ORS and other parties in this proceeding, and you state that their suggested lower return on equity will put the company at a disadvantage in the capital markets and would be a disservice to customers. Have I read that correctly?
That's correct.
I believe, and subject to check, that ORS initially recommended a 9.3 ROE in these proceedings. Is that correct?
That's correct.
And so when you say here that the ORS and other parties suggested lower return on equity, can you tell me what other parties you mean here?
Walmart has certainly suggested a lower return on equity. I believe SCUC has as well.
And do you, as you sit here today...
South Carolina Electric Users.
I apologize.
Consider the microphone.
As you sit here today, are you able to recount what the recommendations were from those parties?
I believe Walmart was 9.67. I don't recall what the SCUC number. I just know it's lower than the 10.5 we've released.
Okay. Thank you. And so it's your position that any of the recommendations from any of those parties is too low. Is that fair?
Yes.
And are you, is it your position as you sit here today that an ROE of that level would disadvantage the company in the capital markets?
Yes.
And can you provide for me what evidence you have to support that conclusion?
The testimony of John Sullivan on behalf of the company and the testimony of Bob Herbert on behalf of the company.
And so you believe that the testimony of those two witnesses establishes that an ROE at a level of 9.67 would be too low for the company to access the capital markets. Is that correct?
Yes, it will disadvantage the company. It's not a question of whether we can access it, but the cost at which we would be accessing it. That's the point.
And is there any other basis or evidence within the record that supports your statement here in your opening statement?
No, I fully rest on those two testimonies.
Is it also your contention that the ROE necessary for the company to access the capital markets is a 10.5% ROE?
Well, I'll put it this way. Witness Herbert's testimony supports a range of 10.25 to, I believe, 11. He initially picked a point of 10.75. And then in an effort to mitigate the impact on customers, we proposed the case built on 10.5.
And so the company continues to support, as you sit here today, the analysis that was done by Mr. Hevert as part of this proceeding?
Yes.
And you were present at the rate case hearing involving DEC, were you not?
I was.
And you saw that Mr. Hevert was asked some questions on cross-exam about whether or not his proposed ROE had ever really been adopted by other commissions in cases where he had offered testimony. Do you recall that line of questioning?
Generally, I do, yes.
And do you recall whether it be his response to the ORS discovery request or his responses to my questioning in that particular proceeding that he acknowledged that there were no instances where his proposed ROE has been adopted in recent years?
I recall him saying that there were some that were adopted that were within his range of reasonableness.
And so none of that testimony has altered, right, let me re-ask that question. None of the testimony or questions that Mr. Hevert provided at the DEC hearing have changed your understanding or belief as to the appropriate ROE to seek in these proceedings. Is that fair?
That is fair. No, my position has not changed.
And do you believe, so I guess it's also correct to the extent that you support Mr. Hevert's testimony that you believe that you are presently disadvantaged in the market in terms of accessing capital markets. Isn't that true?
Yes. To the extent that we're not earning, our current allowed return for DEP is 10.1%. In this case, we have, I'll tell you, we file quarterly surveillance reports with this commission reflecting how much we're earning on return on equity. I can assure you we have never earned that 10.1% since it was allowed to us. In this case, part of why we're filing this case is because our overall return on rate base is 4.1%, I believe.
So help me understand, Mr. Gartitego. What about those reports that you've just mentioned warrant an increase in your current return from what it's currently set at?
Yeah, they all suggest that the company is not earning a fair rate of return. And again, every time you come in for a rate case, I think witness Hurwitz will say it better than I'm doing and did a better job the last time around. You do an analysis based on current facts and circumstances, right? So the fact that I can tell there was a time when the company was allowed to earn more than 12%. It doesn't mean that today's number is 12%. No. So every time you come in for a rate case, you do another analysis of what the appropriate return on equity should be. Again, we're setting rates prospectively. We're not setting rates retroactively. So his analysis in the context of this case shows that 10.75 or the 10.5 we have requested in this case is appropriate.
So you've generated at least two questions for me. I don't think that your response just now was responsive to my earlier question. What I'm attempting to understand is what evidence is before this commission as we sit here today that justifies an increase from your current ROE of 10.1 to either the 10.75 that Mr. Hevert has proposed or the lower 10.5 that the company has indicated it would accept?
I will tell you, my answer was fully responsive to the extent that I explained to you. Witness Hurwitz did an analysis based on today's facts and circumstances that show that the appropriate reasonable range for a return on equity is 10.25 to 11%. And he proposed a 10.75, and we are only asking for a 10.5 in this case. There's abundant evidence in the record based on the testimony that he will take the stand to support in a few days.
And so do you believe that we should look to Mr. Hevert's recommendation as better evidence of the appropriate ROE, or do you think that ROEs actually adopted by commissions is a better indicator of the appropriate return on equity?
I think the commission should look at the evidence presented in this case. I think the law actually prevents the commission from just looking around the country and saying, this utility's cost for X is $10, so that should be Duke Energy's cost. This utility's cost for putting out poles and wires is $20, so that should be Duke Energy's cost. I think the law requires the commission to determine Duke Energy's specific cost. ROE is a cost. It's the cost for raising equity capital. And although there is no science, or it's both a combination of art and science, I don't think you can go to the marketplace and say, pinpoint, this is the cost. That's why commissions depend on experts to evaluate the marketplace. They use proxy groups, they use different methodologies, and come up with recommendations. And it's up to the commission, which is an expert in itself, to determine what that number should be.
Mr. Gartetago, I'm trying to understand how your current testimony squares with the company's willingness to accept a 9.9 ROE in North Carolina. You're not contending that when you accepted that 9.9 as part of the stipulation entered in that case, that number was somehow not a fair return for the company to earn, were you?
You know, I'm saying in that case, and let's put it in context, it was a settlement agreement including that and some other things, right? So in a settlement, perhaps I may agree to a 9.9, but we're not settling that issue or, you know, the combination of issues that were settled back then, and this, and that's why, again, in that case too, Ms. Hurwitz supported a range, and like he's doing in this case, and we believe what he's recommended is reasonable, and it's up to the commission to decide.
Thank you, Mr. Gartetago.
Thank you.
Okay. All right, since it's 12:26, I believe we're going to go ahead and break for lunch, and we will be back at, let's shoot for 1:38.